Hi, this presentation is on HIPAA, that is Health Insurance Portability and Accountability Act. HIPAA provides for privacy rules for protected health information, and we'll also discuss about requirements for clinical trials under HIPAA privacy rules. HIPAA in USA is Health Insurance Portability and Accountability Act. HIPAA was implemented to improve efficiency and effectiveness of healthcare system by requiring HHS, that is Health and Human Services, to adopt national standard for electronic healthcare transactions. HIPAA also included a provision that required HSS, that is Health and Human Services Department, to adopt federal privacy protection of individually identifiable health information or protected health information for assuring continued privacy of health information. HHS, that is Health and Human Services Department, adopted the regulations which are also called privacy rules or HIPAA privacy rules with effect from 14th April 2003. These privacy rules require covered entities to implement standards to protect and guard against misuse of protected health information or individually identifiable health information. Now, covered entities may be the health insurance plans, companies which are providing health insurance. They may be healthcare providers, that is clinicians and physicians, or healthcare clearinging houses. Most healthcare providers are considered covered entities and they are subject to HIPAA privacy rules requirements because they file for insurance reimbursement, which is a type of electronic transaction triggering HIPAA applicability. Now, coming to protected health information. Now, what is protected health information? It is individually identifiable health information that is collected from individual patient that either specifically identifies the patient, for example, with name or address or social security number, or which information which could reasonably be used to identify an individual, for example, with gender or age information in connection with unusual disease conditions like HIV. Protected health information includes what physician regards as personal health information, such as patient medical charts, the test results, the billing information, etc. Protected health information also includes identifiable health information about clinical trial subjects, which is gathered by researchers who is covered healthcare provider. HIPAA privacy rules requirements for clinical trials. That means requirements in clinical trials under HIPAA privacy rules. Clinical trials are permitted by HIPAA privacy rules. However, under most circumstances, the researchers need both written authorization and informed consent from participating patients. Patient authorization form should state that the patient health information will be disclosed or shared only when required by law to prevent and control injury or spread of disease, and no publication or Public presentation will reveal patient identity. An informed consent form should provide details on study method, timeline for clinical trial, potential risks associated in the trial, participants' confidentiality maintenance during trial, health coverage to be provided to participants during clinical trial, etc. For medical record privacy, it is important for sponsor or company doing clinical trial and CRO or contract research organization which is doing clinical trial and clinical investigators and IRB institutional review board to be aware of privacy requirements under HIPAA. So whosoever are involved in the conduct of clinical trial should be aware of the privacy rule requirement under HIPAA. Now coming to HIPAA, clinical investigators. So clinical investigators should be aware of the HIPAA privacy rules. Clinical trial investigators need to understand the privacy rules, restrictions on use and disclosure of protected health information for research purposes. When clinical investigator is covered entity, he must provide all patients with written notice of his privacy practices and patient privacy rights. Clinical trial investigator should also obtain the written authorization from all research participants before disclosing any information for research purposes, unless there is a institutional review board or privacy board waiver for that. Clinical trial investigators should have written agreement with all parties to whom he releases such confidential or protected health information, and such agreement is called business associate agreement for safeguarding protected health information. Clinical investigator may be required to sign such agreement with the sponsor or company and institutional review board, because they may receive such protected health information when the investigator sends the clinical trial reports to them. Any violation of such agreement by business associates may be reported to Health and Human Services Department. Now coming to protected health information use for research. Privacy rules permit covered entity to use or disclose protected health information for research under following circumstances and conditions. First, if the subject of protected health information has granted special written permission. Second, for review preparatory to research, for example, review of medical records to find sufficient number of participants in the clinical trial, that is to identify the research participant, but the participants should not be contacted. Next is for research solely on descendants information with certain representation and documentation obtained from researchers. Next is if IRB, that is Institutional Review Board or Privacy Board, has granted waiver for authorization. Next is if protected health information has been de-identified by removing the, for example, name, age, or social security number. So by removing the identifiable information is called de-identified, identification. So if PHI or protected health information has been de-identified in accordance with the standards of privacy rules, in such case the health information is no longer protected health information and such information can be used. Next is if information is released in the form of limited data sets with certain identifiers removed and with data use agreement between researchers and covered entity. Next is under grandfathered informed consent of individual to participate in research on IRB waiver or other express legal permission. Next is permitted protected health information use. Privacy rules permit covered entity to use and disclose protected health information for purposes of treatment, payment, and healthcare operations without authorization. Privacy rules also permit disclosure to business associate under business associate agreement to protect protected health information, or also permit disclosure to health authorities as required by law. Privacy rules also permit ADR reporting as per law, that is adverse drug reaction reporting as required by law, by using minimum identifiable information, for example use of patient code instead of patient name or ADR code, etc. HIPAA privacy rules violation may result in civil, monetary, or criminal proceedings. HHS, that is Human Health Services Office for Civil Rights, enforces HIPAA privacy rules. That's all in this presentation. Thank you very much.